I will. But who is asking the questions? Okay, so if you would remember, the case is in two parts. Yeah. There was one on contempt, which through unanimously, the applicant, Honorable Ernest Kumi, filed a certiorari application to have the contempt and the conviction by the Akwatia court quashed. Yeah. You remember that, right? Yeah. So, by decision of 4-1 today, the Supreme Court has agreed with Counsel Nimaku and said that the contempt application, its hearing, and the subsequent conviction on it all has been quashed. So, as we speak right now, Honorable Ernest Yaw Kumi remains the MP, the elected and valid MP of the good people of Akwatia. Thank you. And on the second issue was the matter of the petition itself. On that, the court said that the judge, the learned trial court judge in Akwatia, can no longer sit on that matter because his conduct has shown that he should not be allowed to continue sitting on the matter. So even though we may go back to Akwatia, but he won't be the judge to sit on the substantive matter. Thank you. But our main contention at the Supreme Court was that the contempt, its hearing, it's the conviction subsequent to the contempt, the sentencing. If you remember, there were even attempts to have Ernest Kumi arrested, Honorable MP. All has been quashed by the Supreme Court. So as we speak right now, Honorable Ernest Yaw Kumi remains the MP of the good people of Akwatia. The conviction, the bench warrant, if you would remember, there was a bench warrant issued by the High Court of Akwatia. It has been quashed as well. No, I'm referring to the injunction that was granted on June 6th, ahead of the June 7th. Yes, it was stayed. The bench warrant was stayed by the Supreme Court to abide the ruling today. So as at now, per the ruling of the Supreme Court today, no bench warrant exists. So everything has been quashed. He's a free man and he will continue his good work as an MP.
But the question is, you remember that the court issued an injunction against his swearing in as an MP for
everything has been quashed. Because all those things were incidental to the conviction for contempt and all that. And the subsequent sentence, bench warrant by the trial court of Akwatia. Everything has been quashed. Ernest Yaw Kumi Honorable is as free as bird. So now, the debate about the petition pending before the Akwatia High Court, the Supreme Court said we should go back to that, but has prohibited the judge from sitting on that particular case. So yes, for that one, we may go back. I mean, we leave it up to them. We believe that it has no merit, but if they will pursue it, it's their own cup of tea. But let me put it on record. Honorable Ernest Yaw Kumi is as free as a bird, and he remains the elected, sworn-in member of the good people, member of parliament for the good people of Akwatia. Thank you.
Council, I mean,
okay, so yes, the Supreme Court has spoken, even though we are yet to get the reasoning behind it. But essentially, what they are saying, it's not really a 4-1 majority decision with regards to the first one. You know, the petitioners or the applicant filed a few reliefs, I think about 5 of them, with regards to the substantive matter. The Supreme Court, by unanimous decision, dismissed the 2 reliefs out of the 5. And no, 3 reliefs, and then the 1, 2, 3, and then the 2 which essentially bordered on the contempt and prohibiting the judge from proceeding to hear the matter. Is what was greeted with a majority decision of 4-1, and so we await the decision and then the reasoning, and we take it from there. The other matter also had 4 reliefs, 3 substantive reliefs, and then 1 which is the normal 10 lawyers, which is that any further orders, and that also the court dismissed 2, the first 2, and then granted unanimously the 3rd one, which 3rd one also borders on the contempt, which the court, they were asking the court to vacate the ruling on the contempt, which the court actually obliged them and then granted same. And so essentially, per what we heard from the Supreme Court, the petition stands, the matter would go on unabated. But essentially, it is the contempt that had that decision of the 4-1 majority decision. So we will go back and then we await the reasoning, and then we will advise our clients on the next week. That notwithstanding, there is still a valid petition, because you recall that the thrust of their case was that there was no Gazette notification, and that has been the thrust of it. Today, the court has dismissed that application. Essentially, what the Supreme Court is saying is that there was actually a valid Gazette notification, and so there is still a petition, so to speak, a valid one against the Ernest Yaw Kumi. And so we will go back and then advise our client, but there is a valid petition against them, and we'll pursue it.
For clarity, you secure
by way of the decision of the Supreme
Court. The learned trial judge cannot proceed with the contempt, but the actual case still subsists. But the contempt application is what the court disagreed with by a majority decision. But the substantive matter, there is nothing that prohibits as far as we are concerned. And so that is what the Supreme Court has said. We await the reasoning. We may advise our clients going forward. But like I said, the substantive matter, which is the petition, which they sought to declare as void because there was no valid Gazette, has now been defeated. The court says there is a valid Gazette, and that the petition is a valid one. So we may proceed from there.
Okay.
You would also recall, let me put this across, you would also recall that we made a case against him. We told you at the last date that we had made a case against him with regards to the perjury and then the forgery. And that has a link with the Gazette, which has now been pronounced upon by the Supreme Court. And so we will pursue that matter. As I speak to you, the matter is with the CID. We are aware that they've gone to take the caution statement of the Member of Parliament, Ernest Kumi. The duplicate copy has been sent to the Attorney General's Department. We await the advice from the Attorney General's Department. That matter, as I have always said, is distinct and separate from this. Because if you submit a Gazette notification which is forged, which is fake, it is a purely criminal matter which will be pursued. So I can assure you that it's not over. In fact, that is even a more serious matter. And now that the Supreme Court, some way, somehow, has said that there was a valid Gazette that has to do with ours, it puts into question what they submitted. And so this ruling would assist the criminal case we are doing at with the Attorney General and then the Ghana Police and the CID. And so we will pursue it from here. And then they may have to explain where they got the Gazette notification now that the Supreme Court has declared what they had or they filed as void or as fraud, or let me put it as not original at this point. We will pursue where they got that from, because if you submit the document to the Supreme Court and the High Court, which document is not valid, it puts into question what the intention is. And so there is that issue or that suspected crime of forgery and perjury, and that is what we will pursue from here. And I can assure you that that matter would also be pursued.
Okay, all right, thank you, Counsel. Oh, go for it.